Hello. Okay, we're doing a little bit of court review here as we are heading into this Labor Day weekend. And I wanted to share a recent one that was wonderfully synopted by Adriana De La Torre. And I love going through her stuff because she is um, my go-to read with all of these cases because it takes time to get through them, and she gives us a good little synopsis of the really important things that we kind of need to know about the cases. So this one concerns the 11th Circuit. I have cases in the 11th Circuit. I have them in likely every circuit in the country at any given time. Anyway, this one it came out on, it looks like August 2nd of 2024. And it is Rich versus Commissioner, presumably O'Malley of the SSA. And I'm just going to go through with you what she said, and I'll put in a couple comments if I think they might be helpful. This one discusses and impacts the analysis of medical evidence and disability claims. So it's that issue, how we analyze or the judges analyze evidence in the SSA claims. And in summary, she says, it's a reminder about the duty of the ALJs to thoroughly evaluate medical opinions, especially in cases involving nuanced cognitive and psychological conditions. And I'm thinking that's particularly important because there's less objective evidence when it comes to psychological conditions, right? It's so intimate with the provider, assuming they actually get to know their patient and all that very well. So another thing I want to bring out, it'll come in later, but you may as well know it now. In this case, the circuit court reversed the ALJ. You often hear these cases where the ALJ's decision was upheld, and whatever reason the claimant and his usual attorney argued that it should be remanded or with an order to do XYZ that wasn't done. And those things often fail. There's often a finding that the judge had the discretion to do what he did, whether or not one agrees with the outcome or not, but that was within his discretion. So here we go. The claimant was a 33-year-old plaintiff seeking numerous things within the Social Security Administration scheme. That would be SSI, DIB, which is the same as SSDI. For those of you that don't know that other acronym, I know there's like a million acronyms and some have multiples, right? Very annoying, particularly the ones that sound the same, right? SSDI, SSI. People routinely mix those up. He also applied for children's insurance benefits, CIB, which is likely DAC, I'm thinking, since he was 33. Okay, so amongst his disabilities included cerebral palsy and ADHD. His claim was primarily supported by a neuropsychological evaluation by a doctor. In this case, her name happened to be Dr. Messing, not that that's particularly important, because her evaluation detailed his limitations and recommended workplace accommodations to mitigate his impairments. So that right there is something that I'm going to keep in the back of my mind at all times. The fact that she detailed the limitations, but she also recommended workplace accommodations to mitigate the impairments that perhaps needed them in order to successfully get through that work. And I need to take this jacket down. Pardon me. That was in case it got a little nippy, but it's not. It's still pretty warm. Okay. So Adriana explains that the appeal hinged on a critical legal question, and that one being, did the ALJ properly evaluate the doctor's recommendations under the framework required by the Social Security regulations? The regulations require that the ALJs consider the supportability and the consistency. Those are two things, supportability and consistency of medical opinions when determining the RFC. If you recall, RFC is residual functional capacity. It's something they have to do and figure out for someone before they head into step 4 from step 3. right? We have to know the RFC if you're not going to prevail on a listing. Okay, supportability, consistency of the medical opinion. So let's get into that, a little bit of what that is. First, they go on to say that the ALJ had summarized the doctor's findings without explicitly addressing how they influenced Mr. Rich's ability to work. The ALJ also failed to consider the supportability and the consistency of the doctor's work-related recommendations. So she gives a little definition here that'll be helpful to you, I think. In terms of supportability, that is the extent to which objective medical evidence supports a medical opinion. So it could be the objective evidence that she has in her own file, or that which she may have gleaned from others, perhaps. Does other evidence support her medical opinion, particularly on those work-related accommodations, or are they just kind of like an outlier over here? Okay, supportability. Consistency. That is the alignment of the opinion with other evidence in the record of Dr. Messing's work-related impairments, both of those tours. So we have supportability is there objective medical evidence that supports the opinion in the medical file, and consistency, does the medical opinion align with other evidence in the record? So that's not necessarily diagnostics per se, but being consistent, supported by, and consistent with. So something that is inconsistent would fly in the face of that second requirement. So if something was inconsistent, a judge could use that ostensibly to support his reduced maybe weight given to that doctor's opinion if there is an inconsistent record. So if there's a different piece of evidence that is contrary to this piece of evidence, therefore making it inconsistent. So supportability is there other stuff, and consistency is everything pointing to that, consistent with that, or is there anything inconsistent? Okay. The circuit court found that the ALJ's approach was insufficient. We don't see this that much on here, do we? I feel like everyone that I've reported on, I am behind by probably 10 with you, I'm sorry, are always where the circuit court upholds the denial. So this is kind of fun. Fun to see a little difference. By not evaluating, this is what they said, by not evaluating the doctor's recommendations for the supportability and consistency standards, and just kind of like not giving her any credit to speak of without doing that, the ALJ did not provide a full and fair analysis as required. The court emphasized that the recommendations concerning workplace accommodations directly related to Mr. Rich's ability to function in a work setting. Duh, right? Which is an essential component of the RFC determination. So I love this. This is pretty good. You know, I might cite to it in non-11th Circuit cases. Not that it would be controlling, but it can be, you know, very helpful, I think, and insightful for a different circuit to see that it applies, you know, even though it's not particularly their own yet interpretation of a rule per se. As a result, the circuit court reversed the district court's decision affirming the commissioner's denial of benefits. Let me just explain that for those of you that don't know the sequence. So when you remember when you get denied by an ALJ, you have the opportunity always to appeal to the appeals council. And you technically don't even, well, it's nice to have an attorney do a brief for you, particularly the one that knows your case, you know, and held it down below, but some won't do it. You can file that AC appeal without a brief. Or if you know of something, if you're legal-minded enough about the matter to know that a judge failed to do a certain thing that you literally see the things that he must go by, because you're familiar with the rules, you could do your own brief. But even if you can't, you can still appeal to the appeals council. And the appeals council, I believe generally, and maybe in all circuits, is required to review the whole case, whether you do one or not. So, and it's funny because we win a lot of remands And it's often not on the things that we pushed forward. It's on something else. So, either way, it's all good. So the district court, they lost at appeals council, Mr. Rich. So lost at ALJ, appeals council declined to review. That's when he had the opportunity to go to federal district court. That I have known at least 2 pro se people who took a case to federal district court and won without representation. So it is doable. I don't do them, although people keep saying you should. It's a great thing to retire into. Maybe in the future one day I will. But so there are very specific and well-trained attorneys who this is what they do. They don't do the in the trenches that we do here. They do the aftermath when it needs to go to federal court. They have to be allowed to take a court in that particular district. So that's a little bit state related, but sometimes they can kind of get waived in, or they have colleagues in other states that they can, utilize for that purpose while they're still headlong into the actual substance of the appeal. Okay, so once you go to federal district court, you are at federal district court. And if you get denied at district court, like this fellow did, your next step is going to be appealing up to the circuit. So that is what he did. And the circuit reversed its own district court, which obviously was a reversal then of the appeals council of a sort, declination to review, and certainly the ALJ. So what do? They remanded. That's something you also have to know, that very often there will be a remand, not a reversal and a handing out of an award. Then they send it back to the judge for the judge to redo the hearing. And this time, judge, don't forget to do XYZ. In this case, judge, analyze under consistency and supportability. That particular doctor's evidence that he didn't give much credit to, but didn't explain why. So anyway, awesome. I'm so glad to see this, because this is a good reminder to nitpick an ALJ decision when he does disregard your doctor's opinion. And they do that a lot. They do it a lot. All right. So that's great. Thank you so much, Adriana, because you really are so good at this, and you help the rest of us practitioners who do things all over the country to better stay on top of it, because you give us a bit of a synopsis so we know where to delve further if that issue is something that we have to worry about, which it will be. All righty. Take care, everybody, and thanks for popping in, and we'll see if there's another one coming up real soon. Bye-bye now.